Welcome everyone to our webinar. All 300 odd people, I think, we've got registered today. I am Craig Burns, manager of the Energy Group within Corporate Finance. I'll be doing the presentation today, but I'll be assisted by Richard Bush, our senior energy analyst within the Energy Group. Richard is going to be pitching questions to me, and so I think just as something to say right from the get-go here, get ready to submit your questions whenever you feel like you have something that you want to get answered. Please through the Q&A button. And so this is the second time we've done this. We did one in June, and so whether this is the first time for you or you participated in that last one, I think there'll be something for everybody here. I've added new content. We're going to get a little bit more informative on a few areas. Just updated the format and the flow a bit as well. So I think there'll be something for everybody here. So hopefully nobody that sat through the last one will find this too repetitive. The presentation will be on the website a bit later today, and the recording itself will take about a week or two to get on there. So please look for those as following this. All right. So with our agenda here, we're going to, I'm going to have a brief purpose that's going to give a little bit of background and as to why we're doing this today. Go through an introduction to get everybody up to speed on the context. Then we're going to talk about the applicability of NI 51-101. Then we're going to go through select requirements of 51-101. We're going to break that up into general requirements and then specific annual requirements. And then we're going to have a Q&A. But to make this interesting, we're going to also throughout provide an opportunity for people's questions to get answered. And so submit your questions, and we'll stop periodically and try to address things. And if Richard's got something at hand at that time, he'll pop on and read me the question, and I'll try my best to answer it. So the purpose of this is to introduce the fundamentals of NI 51-101, which is standards of disclosure for oil and gas activities, to those with little or no familiarity. So who's going to benefit from participating in this? Well, technical, financial, legal professionals involved in the preparation or use of oil and gas evaluations or disclosure. So next we'll move on here to the introduction. So for those that are unfamiliar, the Alberta Securities Commission administers Alberta securities laws. It's entrusted to foster a fair and efficient capital market and protect investors. It is a member of the Canadian Securities Administrators. So the administrators are throughout Canada, throughout the provinces and territories. And the purpose of the CSA is to improve, coordinate, and harmonize regulation. And the CSA lead oil and gas regulator is Alberta, and increasingly we are looked to as the lead or at least the people that other jurisdictions look to for information and our expertise on other energy matters. So we apply our expertise to energy related matters. We've taken this all things energy approach here for the last few years. We have an ongoing commitment to oil and gas. So we really pretty much cover anything to do with energy. Well, for oil and gas, of course, we look at exploration and production. So that would be the NI 51-101 filers. We look at midstream, which includes pipelines, oil and gas services, helium and hydrogen. We also look at lithium from oil field brines, carbon capture, environmental sustainability, including greenhouse gas emissions, renewable energy, renewable hydrocarbons, electricity. And the last one here we have is environmental liabilities, which is obviously an increasingly important area. So in pursuit of compliant disclosure within the Energy Group, we conduct reviews. These incorporate disclosure and technical evaluations. So those would be the reserves reports that perhaps you're familiar with. And these reviews, the purpose of them is to assess compliance with securities legislation. We develop and maintain securities legislation and technical guidance, and we communicate with capital market participants here in Alberta. So that involves such things as, like this webinar, we do as you saw in the initial slide deck, which was the Energy Matters presentation. We did that here in January. We publish reports every year. And we do all kinds of things like inquiries and respond to inquiries and participate in other presentations. So we are active on the communication front. So now we're going to get into the regulatory framework, which is important for, I think, to provide context to everything that comes next here throughout the session. So National Instrument 51-101, we're going to refer to that as NI 51-101. It is the regulatory standard for oil and gas disclosure within Canada, and it applies to reporting issuers that are engaged in oil and gas activities. So we're going to use that acronym. You'll see that throughout the slides here, oil and gas activities. Another thing to note here is you see the first footnote on the slide. As we go through this today, you are going to see dozens of footnotes, and each one of those will take you to where, or at least will inform you as to where you could find additional information. And so the hope is that you can follow up and learn more by looking at those footnotes and following up. So 51-101 addresses general disclosure standards and specific annual disclosure requirements for reporting issuers that are engaged in oil and gas activities. And as I mentioned earlier, when we get later in the slide, we talk about specific regulations. We're gonna break things up into those general disclosure standards and specific annual disclosure requirements. So 51-101, it actually supplements requirements that apply to all reporting issuers. So it is just in addition to everything else that already applies, no matter what industry or type of business you're involved in. So the technical standard for 51-101 is the Canadian Oil and Gas Evaluation Handbook, or the COGE Handbook. And it's the Society of Petroleum Evaluation Engineers, the Calgary chapter of that actually provides oversight. They maintain the COGE Handbook. And if you're interested, you can follow the link there in the footnote to obtain a copy, purchase a copy through the SPWE website. In 51-101, it points to a statement and forms that are required to be filed annually with the Securities Regulatory Authority, which the acronym for that we use throughout today is SRA on CDAR. So CDAR, I'm assuming most people are familiar with that. So that is the website where you'll see regulatory filings for reporting issuers. Also, non-reporting issuers will often be on there as well, especially ones that are intending to become reporting issuers or are in the process of becoming a reporting issuer. So you can go to cdar.com and to see these filings that reporting issuers are responsible for providing on an annual basis. So this includes the three main ones we'll just touch on here, what we call the Form 51-101 F1, the Statement of Reserves Data and Other Oil and Gas Information. And then we have two reports. So we two main reports that we'll talk about here. That's the F2 and the F3. And so the F2, which is the report on the reserves data, contingent resources data, and prospective resources data by independent qualified reserves evaluators, or evaluator or auditor. And the F3, which is the responsibility of management and directors. So that's the report of management and directors in oil and gas disclosure. So we'll talk about those in more detail as we get towards the end of the presentation here today. Also, accompanying the regulatory instrument 51-101, we've got the companion policy to 51-101, which is the 51-101 CP. And that covers the CSA's interpretation and application of NI 51-101. There's also a number of staff notices that are of interest. The main one that we're going to talk about here today is 51-324, which is the revised glossary to 51-101. And that one will be referenced a few times. That includes all the definitions except for, I think, two that are used throughout 51-101 and all the forms in the companion policy. So it is the most comprehensive listing of all of the definitions. It is not actually a part of the instrument itself, but it is a handy place to get those definitions. And then there's 51-327, which has additional information on oil and gas disclosure. So those are the main ones. Of course, The Securities Act Alberta, that is referenced a few times today, and that is another important document. We have the Energy Matters report, which I had mentioned earlier. That was published, the 2022 version was published in December, and along with the Corporate Finance Disclosure Report, which is a much it's not focused on oil and gas. It's a report published within our corporate finance by our corporate finance group every year, published around the same time as the Energy Matters report. But there's lots of interesting information there on financial disclosure that we hope will be of some interest. Then we have financial reporting bulletins. Which there's a couple of out there. There's one on key performance indicators and one on oil and gas retirement obligations. Both of those were published within, well, I guess now would be 6 or 7 years ago. They are published by the ASC Office of the Chief Accountant, and the intention of those is to help you with the preparation of mostly financial disclosure, but there's also interesting information in there as well that will be insightful, particularly the one on abandonment reclamation obligations with helping you through oil and gas disclosure. So all of this information that so far I've talked about is available on our website. So if you go to asc.ca, you'll be able to search on this information, or sorry, search to find this information. You can also find an awful lot of it, particularly 51-101 and the forms and the companion policy and the reports within the Energy Matters tab on there. And so if you just click on that, that will take you to there, and you'll be able to get the instrument, 51-101, the forms, companion policy, etc. So next we're going to talk about the applicability of 51-101. This one is it may upset the flow a little tiny bit here to sort of start with this, as opposed to maybe going through it in the sequence that we're going to go through the rest of the instrument. But the reason why I wanted to put this out front is that it is an area of key concern for most of the stakeholders. It's something that drives an awful lot of the inquiries that we get, and a lot of the conversations, and a lot of the information that we talk about in our reports and presentations around the applicability. Who does 51-101 apply to? When does it apply? And what does it mean when we say that you're engaged in oil and gas activities? So that's a fundamental thing that a lot of issuers find themselves facing. If it's a company that starts out as an oil and gas issuer, it's a little bit easier if they know that there's probably something to do with, they probably heard of 51-101. But then there's other companies out there that maybe are involved in something else, and by way of other business activities, they find themselves involved in oil and gas, and maybe they're not quite sure what that means. And some issuers don't find out until it's too late that they're engaged, and there's actually obligations that are associated with that. So 51-101 applies to reporting issuers engaged in oil and gas activities, either directly or indirectly. And it's really, we talk about materiality a lot. We'll talk about that today here as well. But it applies to information that is material. I don't want to get too hung up on that, but but in reality, reporting issuers are required to disclose material information, and that includes material oil and gas information. But in general, if we're going to be talking about today, I think it's best to probably think about these as being the requirements that apply to companies that or issuers that are engaged in oil and gas activities. And if they are, there's a bunch of requirements, and the materiality is something that's secondary to consider when we talk about those requirements. The next, I think, part of this that's good to get into here is the terminology. There's a lot of terminology that's necessary to understand when we talk about applicability of 51-101. So we're going to go through these, and it might appear to be a little bit dry to talk about definitions, but they're very critical, and this will help set up the remainder of the webinar. So, as I mentioned, materiality. Well, what do we mean by material? Well, for the purposes of 51-101, if we're using that term specifically with 51-101, it's information in respect of a reporting issuer that would be likely to influence a decision by a reasonable investor to buy, sell, or hold a security of that reporting issuer. And This meaning differs somewhat from the definitions of material change and material fact that are used in securities legislation. Very similar, though, in the basic understanding of, or I think the way we would want you to understand in terms of materiality. It is pretty consistent between those two, but we do have within 51-101 a specific definition that is important for you to understand. So. Applicability, oil and gas activities, this term is extremely important. You'll notice here there's a bunch of underlining that I've done, and I've done that for emphasis. And you'll notice that throughout the slides here, that there are slides that will have some underlining, and those are things that, for effect, I think will sort of just want to try to draw your attention. But they're also, because I'm probably going to be going into more detail on those underlined terms and underlying material as we move through this. So I think the most important things to really really understand here when we're talking about oil and gas activity. So we say, of course, if you're engaged directly or indirectly in oil and gas activities, you're subject to 51-101. So what does that mean? Well, searching for a product type in its natural location is probably the one that most people would think about. So, exploration, that would sort of refer to the exploration for hydrocarbons. Product types, we'll talk a little bit more here shortly. When we talk about product types, those are really the hydrocarbon substances that, if you're engaged in oil and gas activities, you're pursuing. So the acquisition of property rights, or acquiring a property for the purpose of exploring or removing product types from their natural locations is incorporated into oil and gas activities. It's also any activity necessary to remove those product types from their natural locations. Those are, I think, probably the key ones here to cover. So it does not include anything that happens after the first point of sale, which I'll talk about momentarily here. So even if you're engaged in oil and gas activities, there is a limit to what we consider to be those oil and gas activities for disclosure purposes. So it's not everything that the business is involved in. It's a certain set of circumstances that fall under, or a certain set of criteria, conditions that fall under oil and gas activities. Anything that occurs after that custody point where there's a transfer of the product types, we call that the first point of sale. Anything after that is not considered oil and gas activities. So anything downstream of that would not be considered oil and gas activities. But I think in general, anything that is not related to the extraction of a product type or its byproducts would not be considered oil and gas activities. I mentioned product type just a moment ago in the definition, and I mentioned those being hydrocarbon substances. So this is the listing here of all the substances that are currently recognized as product types. And each of these has its own definition, and that's why you'll see them. I should mention the italics. When you see italics, that refers to a term that's defined either in 51-101 or 51-324. And each of these will have a definition, and they can be very specific. And I would encourage you to read up on those individual definitions if you would like to understand these a little bit more. And then there's byproducts. So a byproduct is a substance that's recovered as a consequence of producing a product type. And so if you are producing something that is just a byproduct, but that byproduct is not itself a product type, you wouldn't be engaged in oil and gas activities. So the trigger is the involvement with the product types, and then from that there's byproducts that can be related. And oil and gas activities, I think from maybe the easiest way to put this here is oil and gas activities are related to properties. So it's really critical to understand what a property is in terms of oil and gas, or in terms of 51-101. So it includes a number of things. It includes fee ownership or a lease, concession, agreement, permit, license, or other interest representing the right to extract oil or gas. Also royalty interests. So that's one that trips companies up from time to time. They're not aware that an interest that's simply a royalty interest would or could be a trigger for oil and gas activities. and once again, you could be engaged in oil and gas activities, but those individual aspects of it may not be material, so that can create some challenges with in terms of determining what you need to disclose. But if you do have royalty interests, that would be considered a trigger for oil and gas activities. And then there's also the C, the agreement with a foreign government or authority grants you the right to produce the hydrocarbons. So where you don't own the underlying reserves, you simply serve as a producer of those. So if you're involved in that, you would be considered to be engaged in oil and gas activities. I mentioned the first point of sale, and I did explain it earlier, but just to emphasize, the transfer of ownership or the transfer of custody, as we refer to it. So at that point where there's a legal transfer of ownership of those product types, so those hydrocarbon substances that you've produced or you intend to produce in the future, when that occurs, that's the first point of sale. There can also be an alternate point of sale where I won't get into that. You can see the definition of that and learn a little bit more about that in the instrument itself. But you can nominate an alternate point of sale, and which can affect what your first point of sale is. But in general, the most relevant, important one for you to really understand here is the first point of sale. So just to wrap up in terms of applicability of 51-101, there's just a couple of considerations, a couple of key things that I think that just really want to emphasize. And we talk about this in the companion policy in section 1.3, that oil and gas activities is broadly defined. And the way I like to, when I talk about this with people, I like to say that, look, if you think that you're engaged in oil and gas activities, you probably are, and you should probably react accordingly. If you're looking for hydrocarbons, you're thinking about acquiring a property to look for hydrocarbons. If you're actually in the process of reviewing assets for purchase, those things we would consider you to be engaged in oil and gas activities if you're doing those sorts of things. So even if you don't have reserves, if all you have are unproved properties, or you have what we consider resources other than reserves, so contingent resources or prospective resources, or even beyond that, something like discovered petroleum initially in place or undiscovered petroleum initially in place, you could still be considered engaged in oil and gas activities if you have any of those things. So you don't have to have just reserves. So that is a bit of a misconception, or I think we've moved past that more or less. But historically, there was an idea that people had: if you don't have reserves, you're not engaged in oil and gas activities. Therefore, you're not required to do any disclosure under 51-101, because 51-101 wouldn't apply to you, but it actually does. So it also applies to issuers that are not yet reporting issuers if they've filed a prospectus or other document that incorporates prospectus requirements with the securities regulatory authority. So for a company that's say a private company that's in the process of becoming a reporting issuer, if a prospectus has been filed, that's the trigger. And at that point, you would be considered a reporting issuer and, subject to 51-101, I should say. So now we're going to move into select requirements of 51-101. And maybe I'll just stop here and ask if we have any questions. It's a good time, actually, before we get into the requirements. Richard, is there anything anything you've seen so far maybe that you think deserves some attention?
Yeah, we have a few questions rolling in here. So good morning, everyone. We have some questions rolling in from the attendees. And that last section actually fits well for this one. According to the definition, I believe my company may be considered to be engaged in oil and gas activities, but we do not currently have reserves, contingent resources, or prospective resources to report. To what extent do the annual disclosure filing requirements apply in a scenario where there is nothing to report?
Yeah, so if you've got so nothing to report, I guess the assumption would be that they don't think that they have to do, like they don't think that they have reserves or resources other than reserves, and so they would consider that something to report. Well, there's other things to report, and we would still require the issuer to file Form 51101 F1 in those instances, and there are certain areas of that you would be required to comply with, and they're very, very basic, and those are caught under Part 1 of the F1 and Part 6. Those would address such things as, describing your properties and kind of what the activity levels are and what your intentions are. So there's some very basic things that you would still be required to disclose within the F1, and then there would be the F3, which is the report from the management and directors of the reporting issuer. So there'd be the F3 to be executed and filed on CDAR. Now, you would not need to utilize a qualified reserves evaluator, qualified reserves auditor for that. So that's another area, I think, of confusion for some issuers. But I would, and we'll talk about what that actually means, what a QRA and what a QRE is shortly here. But fairly simple to do the disclosure in those situations. But there still are requirements, even if you don't have what you would consider to be something to report, i.e. like reserves or contingent resources. Anything else there?
Perfect. Yeah, next one. Is there anything that can be shared with regards to an instrument, say similar to 51101, or perhaps it will be NI 51101, that will be introduced to regulate the disclosure of energy projects like helium or lithium?
Okay, so lithium is currently caught under 43101, so that's the mining instrument. And so that is already dealt with there. In terms of other things like helium and maybe hydrogen and some of these other things, there are instances where helium, your involvement with helium would trigger 51101 filings. And we've talked about that actually in our energy. We talked about that in our Energy Matters report published in December. There's quite a bit of information in there on how you would proceed if you were involved with helium and how you would get your disclosure prepared and ultimately issued. We break it up there into a couple of different categories to whether you're a company that's currently engaged in oil and gas activities and you've encountered helium, or whether you're a company that was never engaged in oil and gas activities and you've encountered helium that's not associated with product types. There's a number of different scenarios here, and we cover that in that report. Talked about it in our breakfast seminar, and I would really encourage you to look into those. But in terms of whether we're considering policy in those areas, that's always, I think, a consideration to understand what the needs are and for the capital markets. And at this point in time, we don't have an intention to create an instrument specifically for helium. We do have, as I said, requirements within 51101 that are triggered for certain, if certain things are occurring with your helium, depending on how you're recovering it, et cetera. It's association with oil and gas activities. So there is that. So there is a framework that exists. But for pure play helium, we are not currently anticipating a framework for that, regulatory framework or an instrument.
Okay, we have kind of a follow-up to that. How about requirements for geothermal energy?
So geothermal energy, well, that one is even a little bit trickier because we don't have, it would not fall under any circumstances fall under 51101 like helium may, if the helium is a byproduct of recovery of a product type. Geothermal is something that, so it wouldn't be caught under that, and it's not going to be caught under 43101, of course. But there are a bunch of requirements, though, that sort of just general disclosure requirements that would apply around such things as disclosure of material information and that. And we did, I think we could refer people for this as well to our Energy Matters report, where we've talked about these subjects in general, these other energy areas, and the key things that you'll want to keep in mind for disclosure, the kinds of things that you'd want to provide, such things as talking about your interest in your property, where it's located, if you've run economics, and how you would the types of things that you would want to disclose around that. So we do cover that, but we don't actually have a formal instrument, and we don't have an evaluation framework like that we have for the Kogi Handbook for oil and gas, and not considering it at this time. But I think that really our policy focus really is driven by the needs of the marketplace, and as things change, as we see a lot of demand, and if we also see issues with the way companies are disclosing. So it's not just the demand, but it's the fact that if there are issues around the disclosure, if people are doing things maybe in a manner that's not effective, it's not helpful, it's creating a lot of challenges for the stakeholders to understand that information. There could be a defined need for us to step in and perhaps prepare some sort of a regulatory framework for it, but not at the current time.
Okay. My evaluator has provided a summary report with the information required under Form 51-101 F1. Can I file this report as my F1?
No, well, some people do. We highly discourage that. We've seen it. You will need to actually file the F1. I guess what I'm thinking of here is issuers that would not only file the F1, but would file the summary report. So please don't file the reports themselves. And certainly you could not, we wouldn't accept you filing a report in place of an F1. You would need to actually prepare the F1, execute it, file it. So no, the summary report would not take the place of an F1. Is there anything else, Richard, or should we move on?
One last one here, I guess, before we move on. If a company is producing and selling both natural gas and helium, is it appropriate to disclose helium reserves information in the F1 separate from the oil and gas information?
Yes. So we talk about that in our Energy Matters report. So just let me just make this a little bit more clear. If you're producing helium that's associated with the hydrocarbons, yes, you can disclose that in the F1, and we lay out in that Energy Matters report how you can do that. And if there's situations where it's a byproduct, it's going to be integrated into your oil and gas disclosure in your F1. There's also going to be some situations potentially where you're going to be doing things like wanting to disclose reserves and that, which are not something that's currently caught. The reserves disclosure would be something that you would provide sort of separate from that within a carve out, as we call it, within that F1. You could provide that information. So it's separate, but it's also adjacent to the oil and gas information for make it simpler for people. So you could include that information in the F1 if that helium was recovered as a byproduct.
Yeah, I think that's it for this section, Craig. We can move on.
Okay, thanks. So we're going to talk about Select 51-101 requirements. So first off here, just introduction. So again, as we talked about, 51-101 addresses the general disclosure standards, which apply to all 51-101 disclosure. Then there's also the specific annual disclosure requirements. And we're going to talk about these in that order as we move through this. So what I've done here, I've included a listing on these next two slides of the parts of NI 51-101, with the exception of Part 2. Part 2 we're going to talk about at the end because that's the annual filing requirements. So we're going to talk about those. Those are the specific annual filing requirements. We're going to talk about those separate. But here we've provided a list of all the various sections of 51-101, or the parts, I should say. Thought that it would be sort of helpful for people to see what the various areas are for disclosure within the F1, within 51-101. And what we've done here is underline the ones that we're going to actually talk about specifically here. So we will talk about the application and terminology of 51-101, the responsibilities of reporting issuers and directors, the requirements applicable to all disclosure, and then we're going to talk about other information and what we mean by that. So first things first here, general disclosure standards. And we're going to talk about Part 1 here. So Part 1 within 51-101, it addresses applicability and terminology. Now, we already talked about applicability, so we won't go over that again, but we are going to talk about terminology. So terminology is discussed in section 1.1 of part 1, and it includes a selection of key terms and their definitions. They've been incorporated directly into the instrument itself. So this is, I think, the first place where I would encourage people to look if you're trying to understand the terminology that's relevant to 51.101. In addition, though, want to point you to 14.101, which is the definitions instrument. There's also some additional sort of regulatory terminology that may be of interest. It's not specific to 51.101. Those are terms that are more generally used throughout the various instruments, securities instruments. Also the Act, which of course the Securities Act, if you're in Alberta here, would point you to the Securities Act Alberta. There's also the COGI Handbook, and then the staff notice 51.324, which is the glossary to NI 51.101. So we're going to talk about some key terminology next. There's a couple of things here that I just really want to emphasize. So for terms that are used in 51.101, 14.101, the Securities Act, but they're not defined in those. Section 1.2 of Part 1 of NI 51.101 says to refer to the definitions or interpretations in the COGI Handbook. But if there are conflicts between or differences between the definitions between the COGI Handbook, 51.101, 14.101, and the Act, you're required to defer to 51.101, 14.101, or the Act. So I'm going to talk about these terms next, and I think, again, going through definitions can appear to be rather dry, but these will really establish, I think, the context for the remainder of the webinar. But I'm also going to use the opportunity as we talk about these definitions to ad-lib a little bit about some additional information that hopefully will be helpful for you. So the first one that we're going to talk about is Qualified Reserves Evaluators, or QREs. We're going to use that acronym quite a bit here. So what is a Qualified Reserves Evaluator? It's an individual who, in respect of particular reserves data, which we're going to actually define that here shortly, resources or related information, possesses professional qualifications and experience appropriate for the estimation, evaluation, and review of the reserves data, resources, and related information. They also must be a member in good standing of a professional organization to be considered a Qualified Reserves Evaluator. So we're going to talk about that definition of professional organization here as well, and just point you to our Energy Matters report published in December for more discussion on both Qualified Reserves Evaluators, Qualified Reserves Auditors, and professional organizations. Those are, it's a subject that's been really important over the last couple of years, and we've had some issues on in relation to that, or in relation to these things. And so we've talked about it actually in the last two editions of our Energy Matters report, but I would just point you to the last edition in December 2022 for the most up-to-date information, where we go into quite a bit of detail on these terms and what our expectations are around the application of these terms. And Qualified Reserves Auditor is actually very similar to what a Qualified Reserves Evaluator is. But I would just say a Qualified Reserves Auditor is actually a step above. So all Qualified Reserves Auditors will also be Qualified Reserves Evaluators. They are just allowed to do, it really requires additional experience, expertise, qualifications to be considered a Qualified Reserves Auditor. But it is a very similar thing. It allows you to actually audit reserves, which is something that a Qualified Reserves Evaluator is not able to do. So professional organization. This is another really important term. It's a self-regulatory organization of engineers, geologists, or other geoscientists, or other professionals whose professional practice includes reserves evaluations or reserves audits. That admits members primarily on the basis of their educational qualifications. They're required to comply with standards of competence and ethics prescribed by the organization that are relevant to the estimation, evaluation, review, or audit of reserves data. and has disciplinary powers. So in Alberta, APAGA, the CSA considers APAGA to be a professional organization. Another one that I would mention would be the Society of Petroleum Evaluation Engineers that oversees the COGI Handbook. They would be considered they would also be considered to be a professional organization. So if you were going to be considered a qualified reserves evaluator or qualified reserves auditor, in addition to having all the qualifications and work experience, you need to be a member of a professional organization, so a self-regulatory organization. So future net revenue is a term that you will hear often in relation to 51-101 disclosure. So it's a representation of value, and we use it throughout 51-101. So really, it's establishment of value associated with reserves and resources other than reserves. So it's a forecast of revenue estimated using forecast prices and costs or constant prices or costs arising from the anticipated development and production of resources. So resource is a term we use to refer to reserves and resources other than reserves. So contingent resources, prospective resources, etc. Net of associated royalties, operating costs, development costs, and abandonment and reclamation costs. So future net revenue is effectively the total revenue with these things netted off. Now, independence, another important term, and we do talk about this as well in our most recent Energy Matters. Actually, in our breakfast seminar, we went into some detail on this, but also in Energy Matters report, we talk about independence. And independence is something that's extremely important to the annual filings. So you can be a qualified reserves evaluator, qualified reserves auditor, and do prepared oil and gas disclosure under 51-101. But in order to participate in the annual filings that we're going to talk about under Part 2, you would need to have established independence from the reporting issuer. And there's a lot of information in the companion policy as well around independence that I would point you to understand really exactly what we mean. But I think just in general, it'd be very good practice to use good sense when you're trying to understand what independence means. If you've got financial interests, personal interests, anything like that should cause you to question your independence. And it's an extremely important consideration for us when we're doing our reviews to ensure that the people that are preparing the oil and gas disclosure that needs to be done by somebody that's independent, that is in fact adhered to. So I mentioned reserves data earlier, and reserves data is prepared by qualified reserves evaluators and auditors. It's different from reserves. Reserves data is not just the volumes, it's the volumes and the values. So when we talk about reserves, we're generally just talking about the volumes. Reserves data is volumes and values. And reserves data is a term that's used in the annual filings specifically. So it is an estimate of proved reserves and probable reserves and related future net revenue estimated using forecast prices and costs. I think what I would just say about reserves, so reserves we consider, or we define those really as recoverable volumes of hydrocarbons with effectively no risk. So there's effectively no chance that they will not be recovered. It's just a matter of how much will be recovered, which speaks to the various categories: proved, probable, possible, low, best, high, etc. But there is effectively no risk associated with reserves, and they are commercially recoverable, so they are economic. Contingent resources data is another term that we use in the annual filings, and contingent resources data is prepared by QREs and QRAs. They need to be independent. It is an estimate of the volume of contingent resources as well as the future net revenue associated with it. So this term is again used strictly with the annual filings. And So contingent resources, if you just leave the data off, the contingent resources themselves are recoverable volumes that have risk associated with them. That's why they're not reserves. And they are discovered, so they're known to be in a certain location, but they're not commercially recoverable. Once they are commercially recoverable, they could have the opportunity to be considered reserves. Prospective resources data is the same, except that it's undiscovered. So you'll see prospective resources data in the annual, referenced in the annual filings. You have the opportunity to disclose it in the annual filings. And so it is the volumes and the values of prospective resources. And so they are neither discovered nor commercially recoverable. So they haven't been found yet, nor are they commercially recoverable. Maybe there's a good opportunity just to stop there, see if we have any questions. Richard, any questions on that would be good for us to address here now?
Yeah, we have a few coming in here. Regarding QREs, is there a list of professional organizations that the ASC considers acceptable?
Yes, actually. So within the companion policy, within part 1, I believe, we do provide a listing of the currently recognized organizations. There is always the opportunity for people to request, or to come to us and ask if an organization that they are a member of could be considered. We have, that list has been updated. I think the last time it was updated in 2015, but it can be updated for additional professional organizations, to be included in that. So it's not, there's really no limit on, or I would say there's really, we can expand that. Anything else, Richard?
Yeah. When does a QRE or QRA have to be independent from the company?
So anything to do with the annual filings would require the independence. I would also say, in instances, so if annual filings are triggered, so if, with IPOs, if prospectus level disclosure is required, and also just to stress, in terms of required, I would say that, look, if you say somebody is independent, even if it's maybe in a situation where they don't need to be, if you say that somebody is independent, we expect that they're independent under the requirements of 51-101. So they're going to not only be have the education and the work experience qualifications, but they've also got the independence associated necessary to be able to consider themselves independent qualified reserves evaluators or auditors. Anything else?
One more kind of switch tracks here. Why isn't heat extracted from fluid streams produced with oil and gas considered an oil and gas activity similar to helium as a byproduct?
So heat, okay, that's interesting. So why isn't heat? So heat recovery, and well, I think that maybe the simplest way to put it would be oil and gas activities are related to hydrocarbons. Maybe that's the simplest way. So the instrument being called, referencing oil and gas activities, it would, if we're not recovering hydrocarbons, or there's not an association with hydrocarbons, heat recovery wouldn't be currently caught. And the question, I guess, the next question would be, could it be modified? I think if you modified 51-101 to include things that aren't currently, I think you would naturally consider to be included, like things associated with hydrocarbons. I think that would cause potentially a lot of confusion, and I think it would not only confuse people that why there's an oil and gas instrument that's used for disclosure of things that aren't oil and gas related, but also we have situations where issuers don't want to be associated with oil and gas. They want to make it very clear that their activities are not associated with oil and gas, and they would be quite reluctant. And we hear this, we've heard this with respect to helium, for example, where there's some companies that are, they say, look, I explore and develop helium, and I'm using a lot of the same technology as people use in oil and gas. It's going through some of the same facilities, same infrastructure being used. And I'm okay with being associated with oil and gas, and you know, they'd be okay with having having that association. But then we also have companies that say, look, I don't want to be associated with oil and gas. My helium does nothing to do with oil and gas. I'm recovering it from a field where there are no hydrocarbons. I don't want to be forced to disclose under an oil and gas instrument. So I think the same would apply for something like, you know, heat recovery, where you would have to fundamentally restructure the instrument itself to accommodate things that aren't associated with hydrocarbons. And maybe that's the long answer. Sorry for not making it a bit shorter, but does that help? Do you think, did I address it okay, do you think?
Yeah, I think you nailed it.
There's a lot of words there.
Just two more quickly before we move on here. If you report reserves, are you also obligated to report contingent resources?
Well, that's going to come down to a number of things. And that's another subject that we talk about regularly in our Energy Matters report. You know, when do you need to disclose contingent resources? So by and large, you know, you're not going to need to disclose contingent resources just because you've disclosed reserves data. If you have, you know, if they're material, if you have an evaluation and this stuff is material, well, obviously you're going to be obligated to disclose it as you would any information that's material. But do you need to, is the question specific to annual filings? Do they need to do it actually in their annual filings? Because I can talk to that as well. So
I'm going to assume yes, but it doesn't say
okay. So there's not a requirement to include that. There is no requirement for you to include the contingent resources in your annual filing per se. That's one thing that you can actually do outside of the annual filing, outside of the same year end. You can provide that information in different ways. It doesn't have to be in the annual filing. So the contingent resources and the prospective resources can be done separate. And there's a number of reasons for that, but you know, we do have a framework for the disclosure of that within the F1. It's in part talked about in part 7. We'll talk about a little bit more about the annual filings here shortly, and that is where you would normally provide that information if you wanted to include it in those in your annual filing. But no, you're not obligated to. And if you, just because you've done it one year doesn't mean you need to do it in subsequent years. But it really, this all comes down to materiality, and not every company that has contingent resources will necessarily update the information every year. So that creates another complication. But if you actually, the requirement is for you to disclose proved and probable reserves. So the disclosure contingent resources and prospective resources in the annual filing is actually optional.
Okay, last one before we move on here. An engineer whose normal workflow includes internal reserve estimates for drilling approvals, as well as year-end reserves evaluations, do they satisfy the experience portion of the requirement to be a QRE?
Okay, I guess it would come down to really how much time you're spending. We like to tell people that, look, if the majority of your work function involves evaluations and audits of reserves, and it does over the time period discussed in the COGI Handbook. So for qualified reserves evaluators is 3 years, and 5 for reserves auditors. If the majority of your work function involves reserves evaluations and audits, then I think it's fair to say that you can consider, if you meet the other requirements, you could be considered a qualified reserves evaluator or auditor. But I'd say by and large, somebody who, you know, works on year-end reserves in a company, works in terms of, you know, coordinating reserves, but it's not actually responsible for those estimates, does not derive the estimates themselves, does not take responsibility for those estimates, I wouldn't consider to be a qualified reserves evaluator. Qualified reserves evaluator or auditor is really a specialist. It's a step up from just somebody who kind of works peripherally around reserves. But you know, really, it's going to be somebody's going to have to look at their circumstances and determine how much of their time is spent, you know, involved in evaluations and audits. It's not something that I could say, but we would look for the majority meaning. Like, is that your prime function as reserves?
And that's it. I think we can move on.
Okay. Well, I think that's good timing here, because we'll get into next here. We're going to talk about under general disclosure standards. We're going to talk about part 3 of 51-101, which discusses reporting issuer and director responsibilities. And we'll talk a little bit more here around about qualified reserves, evaluators, and auditors. So section 3.2 within part 3 requires a number of things of reporting issuers. It requires them to appoint one or more independent QREs or QRAs and direct each to report to the board of directors on the reserves data, contingent resources data, or prospective resources data in the statement per section 2.1. So those annual filings that we keep referring to. So a reporting issuer is required to appoint an independent QRE or QRA, at least one, and direct them to report to the board of directors on the information that they've prepared that is included in the F1. Section 3.3 also requires, and this is important, a reporting issuer to provide the information necessary to the QREs and QRAs for them to do their work, so that ultimately they can take responsibility for the work they've done. Their portion of the annual filings, they need to get that information. So the reporting issuer is responsible not just appointing them, telling them to report to the board of directors, but also ensuring that they have the information necessary to do their work. Then section 3.4 requires, amongst other things, that the reporting issuer review its procedures relating to disclosure of its oil and gas activities, including NI 51-101 compliance, and also review its procedures for providing information to its independent QREs or QRAs. And lastly, the reporting issuer and the reporting issuer itself is responsible for approving the content and filing of the statement and reports for section 2.1, so the annual filing. So we'll talk a little bit more in more detail exactly what we mean about approving the content and filing, and who's responsible for what in a couple of slides coming up here. Next, we're going to move on to part 5. So part 5 of 51-101 addresses a wide variety of requirements, disclosure requirements for reporting issuers. And these requirements apply to all disclosure by or on behalf of a reporting issuer that occurs publicly in any document filed with the Securities Regulatory Authority, or in other circumstances in which the reporting issuer knows or ought to reasonably know that this disclosure will become publicly available. So you can follow the footnotes here to get some additional information on this. And there is a caveat here that there are some situations where disclosure is specified, or the requirements are specified as applying to just written disclosure, not verbal disclosure. So I would encourage you to go and look at that, follow up on those footnotes, and learn a little bit more if you'd like. So part 5 applies to disclosure documents, whether or not these are filed with the Securities Regulatory Authority. Continuous disclosure filed with the Securities Regulatory Authority, including the filings per section 2.1, so those annual filings. Disclosure regarding securities distributions, so that would be prospectuses and information incorporated as well. Public speeches and presentations, of course with the caveat, except concerning provisions that apply only to written disclosure. And lastly, part 7. So part 7 is one that I thought we would raise, particularly for newcomers to 51-101 that may receive information requests and not be aware of what they actually mean, or even if you know the Securities Regulatory Authority can even make those requests. So those are discussed in part 7. And so a reporting issuer is required to provide information requested by the SRA about the content of a document filed under 51-101. And so this is specific to 51-101. So if we actually use part 7, or we can use Part 7 to request information related to 51-101. There's also under the Securities Act, there's other areas where we can require or compel information to be provided. That it also includes 51-101, but a lot of other things. But so Part 7 is used specific to 51-101. And most of the time, the information that we're going to issue a request for will involve evaluations and audits, so reserves evaluations, reserves audits, or contingent resource evaluations and audits that are prepared by curies and curaes. And I just want to make it really clear, we make these information requests very routinely. Just because we made a request doesn't mean that we've identified an issue. We will look at disclosure and as part of our normal function, and often want to see additional information to try to better understand the disclosure. And so we'll make requests for evaluations. Sometimes we'll just actually request those evaluations just because we haven't looked at that company's evaluations in a long time, maybe never. And we decide it's time just to take a look and make sure that everything is being done appropriately. So I don't want anybody to think that just because they get a letter requesting information that it means that there's automatically going to be a problem. It's hopefully the people will look at it as us just trying to do our jobs and just trying to essentially help the issuer ensure that its disclosure is appropriate and help make recommendations. So lastly, we're going to talk about a couple of other things that are really important with respect to general disclosure standards. And the first one here involves qualified reserves evaluators and qualified reserves auditors. So a couple of things to keep in mind around disclosure. So there's a number of different things that will be disclosed or can be disclosed that are required to be prepared or audited by a curie or cura. And it's not everything. So I want to talk about what those things are that need to have that oversight. So in general, resources, so recoverable volumes, all categories of recoverable volumes, whether we're talking about reserves, contingent resources, prospective resources, discovered resources, undiscovered resources, total petroleum initially in place, reserves data, et cetera, et cetera. Future net revenue that's associated with those recoverable volumes, but not just future net revenue, any value attributed to estimated quantities. So if you've come up with some other determination of value that's not future net revenue, that's associated with a recoverable volume, we would require those estimates to be prepared or audited by a curie or a cura as necessary. And next, also, I think important here to stress is the COGI Handbook's relation. We already talked about the COGI Handbook being the technical standard for 51-101. What exactly does that mean? Where does it need to be? When do you need to make sure you're complying with it? Again, similar to curies and curas, there's very specific areas that need to be prepared in compliance with or in accordance with the COGI Handbook. So that would be estimates of reserves or future net revenue. They need to be prepared or audited in accordance with the COGI Handbook. All categories of recoverable volumes, they must be disclosed using the terminology and category and classification per the COGI Handbook. So anytime you put out estimates, whether they be reserves or resources other than reserves, whether it be a discovered petroleum initially in place, total petroleum initially in place, reserves, et cetera, proved, probable, possible, all that stuff must use the appropriate, the applicable terminology that is used from the COGI Handbook. It must be in the right category, the right uncertainty, low, best, high, proved, probable, possible. Those would be the uncertainties. And in the most specific category per the COGI Handbook. So just want to emphasize that. And then lastly, if a reporting issuer discloses anticipated results, now this is a bit of a mouthful here, anticipated results from resources other than reserves that include a quantity in which the reporting issuer has an interest or intends to acquire an interest, or an estimated value attributable to an estimated quantity. Those estimates must be prepared or audited in accordance with the COGI Handbook. So this, it's, when you look at Part 5, this is talked about in section 5.9. It's we talk about it in relation to contingent resources and prospective resources, but it's really any resources other than reserves. Any volumes or values of those must be prepared. So it's not just reserves, but also resources other than reserves must be prepared or audited in accordance with the COGI Handbook. And then, last but not least, the filings under section 2.1, which are the annual filings, they require compliance with the COGI Handbook and acknowledgement of such. And so we're going to talk about that next. Maybe I'll just pause here and see if there's any questions. I know we talked about QREs and QRAs before, Richard. Maybe there's some follow-on.
We have a couple, I guess. Yeah, we can address them now. I have contingent resources or prospective resources, which I have disclosed in a news release mid-year. If I want to disclose these as part of my upcoming annual disclosure, understanding it is optional to do so, is it required to reevaluate these resources as of the year-end date in order to include these in the annual disclosure? What if there's no new information to incorporate in the reevaluation, like other than price?
Okay, that's an interesting question. So everything in the annual filing is going to have to be at the effective date of that annual filing. So you're gonna date the annual filing, and everything in there is considered to be as of that effective date. So we wouldn't want to see something like, as long as there is a bit of a caveat. Again, there's lots of caveats. There's a caveat if you've included information at the effective date, you can include supplemental information. But first and foremost, you've got to prioritize the information at the effective date. So they would be required to include it at those contingent resources, or prospective resources, I should say, would have to be at the effective date for their annual filing. Now, okay, if nothing has changed, then the effective date of those estimates would, if we're talking about just volumes where there is no value and there's nothing else that has changed, if you consider those estimates to be, you could include those in the annual filing. If an independent qualified reserves evaluator or auditor has made the determination that there is no change, they could simply do that work and attribute a new effective date to those estimates and incorporate them into, and they could be incorporated into the filing itself. Short of doing that, you would want to, if you wanted to not go through all that rigmarole of having them relooked at by an independent qualified reserves evaluator or auditor, you could just continue to maintain that disclosure outside of your annual filing.
Okay, one last one for this section. If a company staff member prepares reserves estimates, can those estimates be disclosed in the public domain?
So is there assumption here that the person that's prepared those estimates is a qualified reserves evaluator or auditor?
I would imagine so.
Okay, so if they are, yeah, they could do that. If the individual is not a qualified reserves evaluator or auditor, they're not supposed to prepare, or that information shouldn't be disclosed. And that I would say, as we discussed the types of information that just a couple slides ago here, the types of information that needs to be prepared or audited by evaluated or audited by a QRE or QRA. So for that information, no, you would not want to put that in the public domain. We've seen situations where companies will put disclosure out there and caveat it by saying this hasn't been prepared by a QRE or a QRA. And we're not looking to be heavy-handed. We would really don't want to discourage companies from telling their stories. But I would say that as the materiality of that information increases, there'll be more focus on ensuring that that information has been prepared or audited by a QRE or QRA. So if somebody wants to put out management estimates and it's something that's immaterial, but they want to include it in their disclosure, we're probably not going to be focused on it. But certainly if it's material information, we're going to want to ensure that it's been prepared or audited appropriately.
And that's everything for this section.
Okay, so let's move on here. So for the last part of this webinar here, we're going to talk about specific annual disclosure requirements. So just a brief introduction. So these are addressed in part 2. So we've talked about these other parts of 51-101. So if we were doing this sequentially, this would have come just after the application and terminology, just after part 1 in 51-101. And so part 2 talks about these annual filing requirements, and a reporting issuer must annually file a statement and related forms on CDAR. We introduced that concept earlier on today. And I also introduced this, that specified information isn't required in the statement if it's not applicable or if it's not material, but the statement and forms themselves must still be filed. So if you're engaged in oil and gas activities, but you don't consider any component of those activities to be material, you may not need to actually provide that information in the filing, but we still require the filing to be executed and filed. That creates a bit of a challenge for people. The reason for this simply is that if you don't submit those filings, when we go through and we look for them, we will note that the filings haven't been made. An issuer can ultimately end up in default if the filings aren't made. The simplest way to avoid all this is to submit the filings, and you don't even need to make reference to the immaterial aspects, but you would essentially date the statement. If you have very little information, date the statement and perhaps just mention the property that you have and what kind of the current activity levels are, and also submit the F3 to accompany that if you don't have any recoverable volumes for which you have independent qualified reserves evaluator estimates or auditor estimates, but still do the filings themselves. So there are examples of the way to present the information in the companion policy. So in Appendix 1 to the 51-101 CP, we provide examples, presentation examples of how you can prepare these tables. So when you look at companies' disclosure, they're always in tables that look rather similar. Most of them have taken the lead from the companion policy on how to prepare their tables, and most people seem to follow those formats. And it's not a requirement, but certainly encourage you to make it simple. So the first document we're going to talk about here is the F1 that we introduced earlier. So the Statement of Reserves Data and Other Oil and Gas Information, or the F1. So this addresses disclosure such as the reserves data, contingent resources data, prospective resources data. So that's the stuff that's evaluated or audited by QREs and QRAs. But it also addresses this other specified information. So it talks about things like activity, drilling activity. It talks about properties that where you don't have reserves assigned, abandonment, reclamation, things like this can be disclosed. So it addresses a lot of widely disparate information, and we call it the Statement of Reserves Data, and we refer to the F2 and the F3 as forms, but then interestingly enough, we also call this the form. It gets rather confusing. We also talk about those other forms as reports. You're going to find lots of terminology when you look through 51-101 and these forms. It can get you rather confusing. It can get to be rather confusing. So when we talk about the statement, we're always talking about the F1. And when we talk about the reports, we're always talking about the F2, the F3, and then the F4. So the F2 is where the independent qualified reserves evaluators and qualified reserves auditors take responsibility for their work that has been incorporated into the F1 itself. And so the F2 is to be executed by one or more independent QREs or QRAs, and we already talked earlier about the appointment of those under 3.2 of the instrument itself. And the execution of the F2 affirms compliance with the COGI Handbook. So when a qualified reserves evaluator or qualified reserves auditor signs off on the F2, they're essentially saying that they've done their work in compliance with the COGI Handbook. And that's a very important thing to be careful with, because some issuers do run into challenges from time to time. And I would just also stress here, changing the F2 to maybe remove that representation about the COGI handbook compliance or things like that is not permitted. So don't modify the forms to suit your individual needs. The statement itself, the F1, there's lots of room there for not disclosing information that's not material. You don't have to even provide information in the same order. But when it comes to the reports, the F2, the F3 in particular, don't make material modifications, don't change the representations. When you sign off on it, you're representing that everything that's in there that has been adhered to and done appropriately, including adherence to the COGI handbook. So the F3 is where the reporting issuer takes responsibility. So it's where the management and directors of the reporting issuers take responsibility for the oil and gas disclosure. So it's to be executed, the F3 is to be executed by 2 officers, one of whom is the chief executive officer, and on behalf of the board of directors by any 2 other directors. The execution confirms approval of the content and filing of the F1 and the F3 and the filing of the F2, but not the content of the F2. So the content of the F2 is the responsibility of the QREs and the QRAs. Lastly is the F4. So the F4 is kind of the forgotten report or form. This is what if you satisfy the requirements of 2.1 of the instrument to include your oil and gas information in the AIF. So if you're not filing a separate F1, F2, and F3 that you would see in CDAR, if you've actually incorporated all that into the AIF, we ask you to file an F4 so that people know where to look for those annual filings. So now we'll move to the Q&A. So what we're gonna do now is a wrap-up Q&A and attempt to answer any questions from that last section or any questions from earlier on. And maybe what I'll do now before I forget is just to stress that we are always available for discussions on energy matters. It doesn't have to be just 51-101. So I'd strongly encourage you to reach out to us with any questions or comments or queries at any time. If after this session you've got some questions that come to mind, or maybe you're not comfortable submitting them right now, please contact us subsequent to this, and we will be very happy to help you. So let's see if we've got any. Richard, have we got any?
Yep, a few final questions here. First one, is it misleading to disclose undiscovered resources?
Is it misleading? Well, that would depend, I guess, on the circumstances around those undiscovered resources. But by and large, no. By and large, if you follow the requirements of 51-101 in particular, the requirements of Part 5, it would not be misleading. We consider it, when you get into undiscovered resources, though, in the annual filing, so if you're under Part 7 of the annual filing, if you wanted to disclose undiscovered resources, we do discourage it. It's certainly with the risk associated with the recovery of something that you haven't even found. A lot of people are a little reluctant to put that in their annual filing, and I think I would concur with that. You can do it if you follow all the requirements of Part 7, but I would say that with the level of risk usually associated with undiscovered, it probably is best to do that outside of the annual filing, but you can do it within the annual filing, but you better make sure that you adhere to all the requirements.
Okay, next one. If a company files an AIF which includes their statement of reserves data, can they also file an F1 on CDAR?
Don't want you to do that. Please no. So if you look at the annual filing requirements, it requires the filing of an statement. So a single statement, and whether that includes, whether that's incorporated into the AIF or it's done separately, we want to see one statement. We don't want to see multiple. And the reason for that is it's going to cause confusion. We want people to know that they go to one place to find the information and there's not multiple places, because then if there is multiple places, people will assume that maybe something's different. And then it also causes confusion around the utility of the annual filings themselves. People will, once we start to dilute, I think, the meaning of those annual filings, there comes a point where people start thinking that maybe they should be filing an F1 at other times and an F2 and F3 at other times. And we really want to be careful on how those are used, and really want people to file one F1, F2, and F3. I understand there are situations where multiple F2s are, it's most expedient to file multiple F2s. We generally don't, have an issue with that, but the requirement is for the filing, for each of these forms of filing, of one.
Okay, you kind of addressed this next question, but just maybe reiterate here. If a company uses more than one IQRE, should an F2 be filed for each, or is it preferred that one F2 is filed with both evaluators' summary and signature?
So, we prefer one, but I understand why two are sometimes most expedient. And again, the requirement is for one, but if somebody submits two and they're in the same spot, either being in the AIF or found separately, but they're easy to locate, and there's not going to be any confusion that somebody's going to go and see one F2 and think, well, that's the F2 for the annual filing, and that's the only one. We just want to avoid that confusion. That's why we say, having one is probably the best. But if you've got two, that's okay. We want to make sure that if I should also say, if somebody is doing one, there is can be a bit of a wrinkle there, where if you're just putting out one, but you have multiple QREs or QRAs, and somebody's responsible for rolling that information up and presenting it in the F2, we just want to make sure that you're very careful that you're not doing anything with those estimates. Like if one QRE is rerunning the pricing, or rerunning the evaluations on a common pricing forecast, you're essentially generating new estimates, and so that creates a lot of issues in itself. So you just be very, very cautious there if you have multiple QREs and QRAs, and how you're actually doing it. Each of those QREs and QRAs would be taking responsibility for their own estimates. It can be presented rolled up, but each independent QRE or QRA would be running it on the forecast and generating those estimates themselves, and then one QRE or QRA could roll it up into one F2. But separate F2s could be okay. But again, make sure they're filed at the same time, found in the same place on CDAR, to reduce confusion.
Okay, and something we didn't really address here, but it's still worth asking anyways. If a company plans to exit the oil and gas industry, it files an F5, will that present any issues if the company gets back into the oil and gas space in the future?
No, it won't. We wouldn't want to, we don't want to discourage companies from being, filing an F5 if they've actually exited, and they're no longer engaged, they don't consider themselves to be engaged in oil and gas activities. We would want them to file the F5 and not to hesitate if they were afraid that maybe they were going to get back into it at some point. I think it's extremely important to be upfront with your investors and with the regulator as to what your activities are. You can always re-enter in the future, and there is no form, like you don't unfile the F5 or anything like that. You would simply just become engaged again, and there would be some material, probably material change filing around that to talk about what your activities are, what your business is currently doing, making very clear to people that you're now pursuing it again.
Okay, one last question here about independence. If an individual met the qualifications of a QRE but was employed by the issuer, is there a situation where this person could be considered independent?
I would have a really hard time with that. Not to say that there's not a way that you could somehow make an argument, but I think it would be the responsibility of that reporting issuer to somehow justify that and be prepared. They would have to be prepared to answer questions around it. Make it very, very clear in their disclosure, but also make it clear to us because we would likely, I can't imagine we wouldn't have a lot of questions around that. I can't imagine, in general, I would say that there is the opportunity to apply for exemptive relief to use an independent and QRE or QRA for your annual filings. And in those instances, we would go through, there'd be an application submitted, and we would review the application. We would review the company, the qualifications of the individuals. We would review the experience. We would review the company's procedures and policies around oil and gas evaluations and disclosure, et cetera. But it's a big, there are a number of, it's a lot of obstacles in your way to getting that exemption. But it is possible. But I would say that beyond that, if you wanted to make some argument that, not even applying for exemption, just assuming that somebody's independent, you better be prepared to answer a lot of questions.
Okay, and that's it for that essentially. But we've had a few people asking about availability of the slide deck and the recording. So correct me if I'm wrong, but I think we said the slide deck will be available today and the recording will be available in a week or two after some editing gets done.
Yeah, and I think we always say a week or two, but I think we generally are, we're quicker than 2 weeks, even quicker than a week often. But there's some editing that's involved, so let's just say it'll be there. Check back maybe in a week, but yeah, today we'll have those slides up, and it should be up could be up any time now.
And that's it for questions.
Great. Okay. Well, thank you, everybody. Really appreciate everybody's attendance here. And again, follow-on questions, please contact us. Contact information at the end of the presentation there. Please, love to engage with you. So look forward to that. And check our website for additional information on future webinars like this, and also to get the information that we talked about in terms of like the policy documents and presentations and reports. It's all there. So thank you, everybody, and hope to see you soon. Take care.